protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated as a contempt of Parliament. It is also a contempt to give false or misleading evidence to a committee. I'd ask all present to ensure that mobile phones are switched off or on silent. In accordance with the committee's resolution of 4 August 2022, this hearing will be recorded and broadcast on the Parliament's website, and the transcripts of proceedings will be published on the Parliament's website. Those present here today are advised that filming and recording are permitted during the hearing. I also remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. Transcripts of today's proceedings may not be available in time to meet the deadline for questions on notice. Therefore, could you please, this is for the witnesses, please keep track of any questions on notice so that you're able to respond in the time required to ensure the committee can meet its reporting deadlines. The committee will now take evidence on the agreement between Australia and Japan concerning the facilitation of reciprocal access and cooperation between the Australian Defence Force and the Self-Defence Force of Japan. We have witnesses here from the Department of Defence and the Department of Foreign Affairs and Trade. I welcome you and your evidence today. For the Hansard record, would you please state your full names and the capacities in which you appear before the committee?
Good morning, Chair. Hugh Jeffrey, Acting Deputy Secretary, Strategy, Policy and Industry Group in the Department of Defence.
Good morning, Chair. Air Commodore Pat Keane. I am the Director General of the Military Law Branch within Defence Legal.
Good morning, Chair. Kate Mitchell from the International Law Branch at the Department of Foreign Affairs and Trade.
Good morning, Chair. My name is Victoria Coakley. I head the Multilateral Human Rights section in DFAT that's responsible for the policy on death penalty.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Good morning, Chair, committee members. Thank you for taking the time to receive us today. We very much welcome the opportunity to introduce the Reciprocal Access Agreement. This treaty represents the work of several years, and I'd like to acknowledge at the outset Australian and Japanese officials who have put a lot of hard work into this treaty, including in particular my RAA counterparts, and Toshihide, Kobayashi Kenichi, Sona Kenko, and most recently Ishizuki Hideo, friends and colleagues all. We're confident that the treaty makes a contribution to Australia's security. In my opening statement, I'd just like to quickly outline the strategic rationale behind the treaty, outline how it will work in practice, some brief observations about some of the challenges and sensitivities we had to deal with, and prospects for next steps for cooperation with Japan under the treaty. So the RAA was conceived in 2014 by Prime Ministers Abe and Abbott as a response to a much tougher strategic environment. As liberal democracies and US allies both believe that a stronger strategic relationship was necessary, in particular that closer defence and security engagement would give both countries greater strategic weight to manage and navigate what the Defence Strategic Update called in 2020 the most significant change in our strategic circumstances since World War II. Now, these circumstances have driven a remarkable transformation in the bilateral relationship with Japan. As you may know, from a relationship that was underpinned primarily by trade and investment since the end of the Second World War, to one where increasingly Australia and Japan see each other as linchpins in their respective regional strategies. And as a result, we've seen tremendous growth in the breadth and ambition of the bilateral defence relationship. But to date, we've lacked the necessary mechanisms to facilitate military cooperation consistent with the level of our strategic alignment. So the conclusion of the RAA goes a long way to addressing that. Practically, it will streamline the arrangements for our militaries to do more together, be more agile, responsive and effective. It will also improve our ability to work together with other partners, including obviously trilaterally with the United States, both our most important ally, and in other multilateral formations where we have similar agreements. And we will believe that the treaty will help contribute to the normalisation of Japan's defence posture, allowing a Japanese self-defence force to take a more active role together with its partners in shaping our region's strategic trajectory so that it continues to support our collective security and prosperities. Now, the time it took to reach agreement, negotiations lasted for 7.5 years, underlines that it was a complex and challenging negotiation. This is the first time that Japan has ever negotiated a military access agreement with another country since the end of the Second World War. Japan has one other agreement with the United States from 1960, but it's unilateral, and it contains components which are controversial and unpopular in Japan, especially around issues like criminal jurisdiction. And this meant that not only were negotiators having to work through a number of legal differences in our respective systems that required time and care to find a mutual way forward, but also that Japan was breaking new ground on its defence and security policy that would both be subject to intense political scrutiny at home and also was designed to serve as a template for future such agreements that Japan might make with other countries. So overall, it was a big deal for Japan and for Australia. And so the conclusion of the negotiations represent a milestone achievement for both countries. So what does the agreement aim to do? Briefly, it's a framework to govern the status of our forces while conducting cooperative activities in each other's territories. The agreement covers provisions typically covered in a visiting forces agreement, which you may have heard is sometimes referred to as a SOFA, a status of forces agreement. It's not tailored to any specific activity, rather it's framed broadly to encompass any cooperative defence activities that are agreed by the parties. And it can therefore be used to cover a wide range of existing and new cooperation across the spectrum. At its heart, the provisions of the treaty enable the receiving state to simplify or expedite processes or allow favourable and equal treatment for the other party's personnel. And in return, the treaty requires the sending state to ensure that its forces maintain good order, abide by the receiving state's laws, take due care for public safety and the protection of the environment and cultural heritage of the receiving state. And the RAA, and this is important, is based on a spirit of cooperation, and this underpins the growing ambition that Australia and Japan share around defence and security. So the treaty structure, you will have noticed, consists of a number of different elements which together create commitments that the parties have agreed to. And that structure involves the treaty text itself, the annex, the agreed minutes, and the record of discussion. Now, it's not unusual for a treaty such as these to have different instruments working together, and it's particularly common under Japan's treaty-making process. And the structure also made it possible for Australia and Japan to negotiate commitments which accommodate each side's existing legal obligations, even where they differ. And to point to a key example, the RAA was negotiated with a view to ensuring consistency with Australia's international human rights obligations, including in relation to the death penalty. Because Australia and Japan's international human rights obligations and policies differ in relation to the death penalty, this was obviously a focus for the negotiators. We took, as Australian negotiators, great care to ensure an outcome that was in keeping with our international obligations. We invested the time necessary to convey this view to Japan, which clearly understood our position. And the elements of the RAA, this element we know has been on some interest to the authors of the public submissions, and we are of course prepared to answer any questions that you have on that front. A brief word about implementing arrangements. These are relatively standard features of treaties such as these, and they serve to assist with operationalising particular aspects of the treaty. The work to prepare the implementation arrangements are ongoing, and they are legally non-binding, and according to normal practice, they are confidential between the parties. They will be finalised prior to entry into force. And there are a number of other areas that the parties have prioritised for implementing arrangements, and where there are technical and procedural complexities, or where there is benefit in clarifying how the treaty commitments will be applied in practice. Implementing arrangements are useful in providing more fidelity for Japan as it drafts enabling legislation for its first SOFA, and also for Australia in determining whether or not legislative or regulatory changes are required. One point to illustrate, as noted in the National Interest Analysis, the implementing arrangement on military disciplinary powers sets out in more detail how Japan and Australia will cooperate closely on this subject to the exercise powers, including arrest and search and seizure. And it sets out, in some cases, the sending state will need to seek the assistance of the receiving state's authorities to undertake actions that the sending state would normally exercise autonomously. This is just one illustration of the principle that underpins the whole treaty, which is that Australia and Japanese authorities will work in close coordination and cooperation. And that cooperation and coordination being central to our deepening defence relationship. And of course, happy to go into more detail about the structure and the function of the treaty if that's of interest to the committee. As I mentioned at the outset, this relationship has undergone huge growth over the last decade. It is no mistake that the Deputy Prime Minister and the Defence Minister of Australia's first bilateral visit overseas was to Japan. Our cooperation on strategic capabilities, space and cyber, defence industry and science and technology are all progressing in line with the broader special strategic partnership that we have with Japan. And we have made great strides in practical military cooperation, which is going to be very important in the context of the issues we're discussing today. The RAA will unlock further gains, prospects for enhanced presence in each other's territories, opportunities for enhancing interoperability, continuing to develop our cooperation in the region bilaterally, multilaterally in support of our partners. And I thank you for your attention, and we look forward to answering your questions.
Okay, thank you. And so no further statements. You're happy to move to discussion? Good. Okay, well, look, I'll begin and then the Deputy Chair will follow me and other members of the committee. Mr Jeffrey and perhaps Air Commodore, if you'd like, I'm just interested if you could provide some more detail on the kind of cooperative in-country activities that this Status of Forces agreement will facilitate, particularly in ways that are separate from the kinds of cooperative activities that Australia and Japan currently undertake or have undertaken in recent years.
Thank you, Chair. So the agreement covers provisions that are typical of a visiting forces agreement, and it includes provisions that address a number of areas that will enable us to do more together. So diplomatic clearance of vessels and aircraft, immigration requirements of civilian and military personnel, exemptions from certain taxes and publicly administered fees, processes for the importation and exportation of goods and supplies, facilitating access to facilities and related services, mutual recognition of licences, certain professional qualifications, carriage of weapons, mortuary affairs, etc. The annex sets out binding understandings in relation to disciplinary matters in criminal jurisdiction, including obligations to assist each other in relation to arrest and transfer of personnel and assist each other in investigations and evidence production. Now, all of that means that the ability of our forces to operate together in each other's territories is now much more streamlined because it's subject to a set of agreements governed under the treaty. Previously, what we would have to do is do this in an ad hoc way to ensure that each activity had the necessary clearances and authorities and processes in place. So this will mean that this treaty will really allow us to scale up our military activities more quickly. And as I noted in the introduction, it will allow us, because it's not specific about cooperative activities, we can use it to grow from what we're doing now into new areas, including, for example, trilaterally with the United States.
But
these kinds of agreements assist in removing the level of ad hoc administration that's required before any activity, because the provisions are all mutually agreed in advance. It's not tailored to specific activities. It's broadly framed to encompass cooperative activities agreed between the parties as we identify things that we would like to do together. It will mean that some of the activities that we conduct in Japan now under ad hoc arrangements, like Southern Jackaroo, there will be. It just makes things smoother for both sides.
Is it fair to say that status of forces agreements contemplate something that's sort of temporarily extended? I mean, obviously at the moment we participate in joint exercises and those kinds of things. If you compare, if we have regard to the status of force agreement that Japan has with the United States, I mean, that has facilitated US personnel being semi-permanently based in Japan. Presumably one of the reasons why you conclude an agreement like this is that you imagine that the presence in country of either Japan in Australia or Australian forces in Japan would be more significant and extended rather than through exercises, the likes of which have been part of our relations for some time.
So this is it's a status of forces-like agreement in terms of what it does. It's not a basing agreement or a security agreement. So this is an agreement that facilitates activities between the parties. It certainly will allow both parties to conduct a greater range of cooperative activities within each other's territory more easily, but things like extended periods of personnel being based in a country that's not something that's covered by the terms of this agreement specifically.
Just for the committee's context, I understand that the United Kingdom is in the process of settling a similar agreement with Japan. So Japan, having had the agreement with the United States for a significant period of time, is perhaps on the brink of settling two new arrangements, and it will be our fifth status of forces arrangement, I believe, fourth or fifth?
Eighth.
Eighth?
Yeah. Yep.
Is that right?
Have to check.
I think we've got four in our papers, but that's good advice. So yeah, I mean, just in terms of the context of this agreement, Japan has the UK agreement under consideration or in process. Does Japan have other agreements like that in process, to your knowledge, and do we have other agreements in process like this?
So, Chair, as I mentioned at the outset, Japan sees this as a template for expanding its military cooperation with other like-minded countries. And yes, it is a matter for public record that they are in negotiations now with the UK on a similar agreement. And it is my understanding, Chair, that the template for that agreement is the one that Australia and Japan have negotiated. And that makes sense. And obviously this question will need to be directed to Japanese authorities, but my understanding is that they are seeking to expand that beyond the UK to other like-minded countries. And as I said, this is because this is a response by Japan and by Australia to a more contested strategic environment. And one of the ways we are doing that is moving beyond a hubs and spokes model with the United States. So typical model would be that you know, with US allies, is that you operate with another US ally through Washington. Rather, what we're doing is building a networked model where we're able to operate independently, autonomously together. We have the authorities to do that together without necessarily the United States being involved, and that is an important strategic response. In terms of the treaty, the SOFAs that we currently have, we have visiting force agreements with France, with Malaysia, New Zealand, Papua New Guinea, the Philippines, Singapore, and the United States. Now, they're all different, they all encompass different things, but we engage in this type of treaty negotiation to encompass defence activities where it's in our interests to do so.
Thank you. Just a technical question about the nature of this agreement. four different instruments: the treaty, the annex, the minutes, the record of discussion, and then there's the implementing arrangements that you've referred to. The implementing arrangements are less than treaty status. They do, certainly in the national interest analysis, they cover some arrangements that go to some critical areas, like the areas covered by Article 21. And the implementing arrangements, as I understand it, will be settled and sort of supervised by what's referred to as a joint committee, not this joint committee, a joint committee that's created through this agreement itself.
That's correct.
But yeah, I mean, it's difficult sometimes. It's not that uncommon, but in this case, those implementing arrangements, I mean, how they pertain to some of the controversial aspects of the agreement is impossible for this committee to see, because they'll be settled subsequently. So I'm not sure. I mean, I think when we get into the discussion around the death penalty, that might be something that you're able to provide some advice on. But I guess I just ask, because we've had one submitter, Professor Rothwell, question the status of the different parts of the agreement, and particularly, I think, the minutes as opposed to the record of discussion. The NIA describes the minutes as being legally binding, or being, part of the documents that are legally binding, and in Professor Rothwell's opinion, that can only really be regarded as a supplementary means of interpretation. Is that something you can offer a view on?
Thank you, Chair. I will pass to Pat in just a minute on the legal definitions with respect to the treaty structure. But just a couple of points in the broad. There is no one way to write a SOFA. Each SOFA and its structure is sui generis, if you like. It reflects the particular negotiations that you had with the country. The structure that we have with this treaty is one that allowed Australia and Japan to achieve the ambition of the treaty while protecting the sovereign interests and reconciling our different legal systems. And while the agreement, yes, it is complex, it's by no means unusual. And it really does reflect that the negotiations, as I mentioned at the outset, were long and challenging and complex. As the negotiations progressed, various parts of the text were settled, and as our mutual understanding deepened over the negotiating period, in some cases it was more efficient to record our understanding in subsidiary instruments rather than open up the treaty text. And that's how the treaty structure evolved. And one important point of principle too, with respect to your comments on the implementing arrangements, Chair, what has been central to our negotiations is to ensure that what is agreed in the treaty text is not denatured by subsidiary documents, but rather that the subsidiary documents help explain what we mean and how we will implement what is committed to into the treaty. But Pat, over to you.
Yep, thank you, Hugh. So the RAA treaty package of documents clearly represents the work of 7.5 years of negotiations between parties with different legal systems and different levels of experience with this type of agreement. In addition to the main treaty text, there's an annex which goes into further detail on the main text provisions related to the exercise of criminal jurisdiction. That is, which country would take action if an offence was to be committed within the territory of the receiving state or host state. The treaty also includes, as a treaty-level document, a set of agreed minutes, which was merely to clarify certain terminology that was used, certain terms that were used in the main treaty text, and also some processes in relation to civil claims. And finally, the treaty package attaches, at a non-treaty document level, a record of discussion between the parties, which clarifies mutual understanding in cases where assistance in relation to criminal matters would not be permitted in accordance with parties' international legal obligations. What this covers essentially is that Australia would not be required to assist Japan in cases where the death penalty may be imposed. And this was a useful mechanism for Australia to record the clear understanding of the parties through this record of discussion on this important point. So this format represented the best way to make progress and meet the needs of both parties at various stages of negotiations. Some texts were settled, but some issues would have benefited from further clarification.
Okay. Well, I'm just going to ask a sort of an opening question on the death penalty, and then I'll move to the Deputy Chair. I think for the committee's purpose, it's worth someone trying to give us the most simple explanation of exactly how Australian service people or related civilians may or may not find themselves subject to the death penalty. So Australia, we are an abolitionist state. We've ratified the second optional protocol. We've adopted in 2018 a very forward-leaning strategy in the way which is not just about how we approach that issue domestically, but how we interact with the wider world. My understanding, it's quite complex, but my understanding is that there's the part of the agreement that goes to the circumstances which Australia would or wouldn't provide assistance in relation to people who are charged. But there's something that comes before that which really has to do with the sort of the jurisdictional question. And as I read it, and I could have this wrong, I think this is important if you can help us understand it, that for the visiting force or civilian component, the first thing that the agreement sets out is that you've got offences that exist only under Australian law, and you've got offences that exist only under Japanese law. And in those cases, either the receiving country, if it was Japan, or the sending country, of Australia, has primary jurisdiction. Where there are offences that are essentially common, my understanding is that primary jurisdiction will be with Australia for visiting force personnel and civilian components if the offence is against one of our own people or against our own property, or if the offence occurs while a person is conducting in the course of their official duties. Yes. So in any of those circumstances, even if an Australian citizen in Japan committed an offence, they would effectively be handed over to Australia and fall under Australia's criminal jurisdiction. But to the extent that a person commits a crime in Japan that can't be regarded as in the course of their official duties, then they would fall under the criminal jurisdiction of Japan. And it is possible in those circumstances, so an Australian member of the Australian Defence Force or the civilian component commits an offence in Japan, which is a common offence like murder, and it's not in the course of their official duties, then they would be subject to the criminal jurisdiction of Japan, and they could find themselves subject to the death penalty. Is that a fair summary?
Chair, thank you. I'll hand over to Commodore Keane to take you through the legal process around the provisions on the death penalty. But just a couple of overall statements. As you have noted, great focus of the negotiations was to ensure that the two countries' differing positions on the death penalty was managed in such a way that each country's legal obligations, domestic and international, were respected, and that we could conduct cooperative activities accordingly. The principle of the around the death penalty focuses clearly on the point of cooperation, as I've stressed throughout this hearing today, that where an incident to occur, obviously we would need to consult closely with Japan. The principle under which we have managed the issue, the differences over the death penalty, that in instances, where we are concerned that there may be a possibility of the death penalty being applied, we are not obliged to assist in that legal proceeding or prosecution, and that non-assistance would not be regarded as obstruction under the treaty. Now, just a point on Japan's judicial system with respect to the death penalty. It's rarely applied. It's not applied for crimes of accidental death, not applied in, for example, in terms of a car accident where that you have caused through multiple fatalities, but not intentionally, and it is exceedingly rarely applied for even intentional crimes that don't involve particularly heinous attacks on people. So when you do see it applied, it is applied in particularly extreme circumstances of crimes. The possibility that we think that Australian Defence Force personnel would be involved in such criminal activity, we think is vanishingly small. But you are right to acknowledge that were our person to commit such a terrible crime while they are not on official duties, that the possibility does. The possibility is encompassed that they could be subject to the death penalty. That's not, exceptional. We have cooperative agreements with other countries where they also would be exposed to the full scope of the domestic legal system, to include the United States. So it's not something that that is unique to Japan, but something that we have to manage as we deploy our forces globally. But I'll just leave it at that and ask Commodore King to just speak to your characterisation directly.
Thanks, Hugh. And Chair, you have summed up the jurisdictional division between Australia and Japan very well. That kind of division of jurisdiction is a pretty common feature of agreements of this kind. It's one of the issues that is commonly dealt with in any kind of visiting forces agreement for one country in the presence of the other. Exclusive jurisdiction over the visiting force goes to the visiting force in relation to disciplinary matters and matters that are within the criminal laws of the visiting state but not the host, and vice versa for the host state, where it's not a matter within the criminal laws of the visiting state. Where jurisdiction is concurrent, normally some arrangement is made to work out who has primary jurisdiction, and the formulation used in this agreement is a fairly common one, which is where those offences of the visiting force relate to the personnel and property of the visiting force or occur in the course of official duties, then primary jurisdiction remains with the visiting force. And as Hugh has outlined, for circumstances where the host country had primary jurisdiction, then they would be subject to its jurisdiction and to its laws.
I wouldn't mind hearing from the DFAT people just on their view about the extent to which the agreement as settled. I mean, I understand all that's been said. Obviously, if it had been possible to have a form of agreement which simply made it clear that under no circumstances would Australian citizens be subject to the death penalty, that would be black and white, wouldn't it? And this is not black and white. I mean, this is an agreement that does have open the possibility of Australian citizens being subject to the death penalty. And I hear, Mr. Jeffrey, what you say about it perhaps being vanishingly small. I was in this committee not that long ago when we were talking about the provision of nuclear obligated material to the Ukraine. There was a conversation about the possibility of Russia invading the Ukraine and a nuclear facility falling into the hands of Russian forces, and therefore our uranium falling into the hand of Russian forces. And I remember people in the same room not perhaps using the term vanishingly small, but the suggestion was that was very, very unlikely, and yet here we are. It's salient to note that Japan does have a quite different criminal justice system to what we have here in Australia. Some of the material we've been provided suggests that the prosecution rate runs at about 99% or 98% or something. One of the reasons why the death penalty is so abhorrent is because there are no comebacks from the death penalty. I mean, and history shows that systems like the United States and others get it wrong. That's why it's so serious. That's why we have the position. But I am interested in the extent to which, this is a relatively recent strategy. 2018, we adopted that overarching strategy through DFAT. I'm interested in the view to the extent to which that and this agreement are consonant.
Thank you, Chair. I might start. And thank you for highlighting this is a very, is a tricky space in which obviously to negotiate. We have our overarching strategy. We do believe that the procedural safeguards that have been put in place in this reciprocal access agreement is consistent with the strategy. The strategy, as you referred to it, doesn't actually consider government-to-government assistance or police cooperation in death penalty context. So those are covered by other acts, such as the Extradition Act, mutual assistance in criminal matters, and obviously in police-to-police guidelines and assistance. So the negotiation, as my colleagues sort of highlighted, this was obviously an issue that was one of the foremost issues, sticky issues between the two countries. And what they have is this package that's seen as a whole. So the treaty, the annex and the record of discussion is a whole. It's not separate. So it is an understanding of how things would happen in the event that hopefully it wouldn't happen, just given the assurances and the high standard of ADF personnel would eventuate. So we do think that the procedural safeguards are adequate for the RA at the moment. And obviously, if an Australian did end up in a situation, the Australian government would make wouldn't shy away from making all sorts of representations to try and assure extradition or something else, but I can't speak to that any further. And just to note that in Japan, it really is that most heinous crimes that are subject to the death penalty. It's not drug trafficking, it's murder.
They've hanged nearly 100 people since 2000, and they have 100 people on death row presently. I'm not sure if any of them are foreign nationals. I don't think there's ever been a jurisdiction that's applied the death penalty for anything other than very serious crimes. But they get applied wrongly. And in any case, I'll let the Deputy Chair ask some questions, then other committee members.
Thank you. 7 years, long time. What was the biggest touch point? Was it the death penalty?
There were a number of issues. The death penalty and how to ensure that the legal obligations of both sides were respected was a major one. Chair, you mentioned earlier about and we noted with interest, one of the submissions, I think, why did we not, why could we not secure a clear exemption or a clear statement? I think, Deputy Chair, you can take from the length of the negotiations the fact that we were exhaustive in relation to options, discussing options that would allow us to address this death penalty issue. The arrangements that we arrived at were ones which, in my judgment and in the judgment of our colleagues, was the only way that we could secure this agreement. And in my view, and I think this was a consensus view, we would not have arrived at this moment were we adamant that we had to have some form of exemption or some kind of statement from Japan that it would not apply the death penalty. As you can appreciate, Deputy Chair, history was a very important silent partner in this negotiation. And the idea that Japan would voluntarily surrender aspects of its sovereign system, including criminal jurisdiction, was just really a non-starter for Japan.
Sorry, just for context on that point, Mr. Jeffrey, and it's probably salient for the committee to understand, I think one of the concerns for Japan is that the agreement they do have with the United States operates in exactly that way, and that's created a lot of domestic political issues. But the agreement between Japan and the United States, any US citizen, either defence or related civilian personnel, if they commit a crime in Japan, they are handed over to the Americans. And that's that's something that Japan didn't want in this agreement.
That's correct, Chair. The history here is, as I mentioned earlier, Japan has one other agreement, access, but it's unilateral, so it applies to the United States in Japan, not Japan in the United States, and obviously the US military presence in Japan is incredibly important to Japan's security, important to the region's security. But aspects of that agreement are extremely political in Japan, one of which is the status of US personnel that commit crimes off duty and where they are tried, and not being subject to Japanese judicial system is extremely sensitive. So you can appreciate this is one of the aspects that was so challenging for us to negotiate.
And you know, I can understand that. Death penalty is off the table. Heinous crimes being committed. What's life in prison in Japan?
You mean in terms of the sentence?
Yeah, sentence. So bad crimes being committed, punishable by death under their law. They've agreed to not do that. What's life?
I might need to take that on notice, Deputy Chair, unless anyone else knows what a typical life sentence is. I think it varies, but to give you an informed answer, I'd need to take that on notice.
If there's a dispute between the sending state, sending nation, receiving nation, what mechanisms do you have to iron that out and to ensure that best practices are followed?
Well, I'll pass over to Air Commodore Keane to talk through the legal the mechanism as agreed under the treaty.
The mechanism is established within the treaty terms through the Joint Committee, which does also, it sets out those implementing arrangements which were discussed earlier, but it's also the framework through which we would conduct a consultation and cooperation in relation to dealing with particular issues or incidents, and that is the first place that we would go in relation to an incident of that kind.
Right. And you said before you're not obliged to assist. What do you mean? What do you mean that you're not obliged to assist?
Probably best to lay out the treaty framework a little bit to help to understand that. In general terms, the treaty requires both parties to assist one another when it comes to the exercise of their respective jurisdictions that have been set out in the treaty. However, there are some exceptions to that obligation of assistance. And importantly for Australia, the key exception is where such assistance would not be in compliance with our international legal obligations under the International Covenant on Civil and Political Rights and the Second Optional Protocol in relation to the abolition of the death penalty. So Australia would not be required to assist Japan with an investigation it was conducting into a matter where there was a real risk that an Australian citizen might be the subject of the death penalty.
Obviously, that assistance is most relevant if in effect, a member of an Australian citizen is more or less in the custody of Australia. I mean, the bottom line is if an Australian commits a crime and they are taken into custody by the law enforcement of another country and then subject to those proceedings, I mean, the kinds of assistance that we would or wouldn't provide would be relatively limited and relatively immaterial to that person's circumstances at that point.
Well, one of the forms of assistance that Australia would not be able to provide in any case in which there was a real risk of the death penalty being applied would be investigative matters, so in relation to the production or handing over of evidence or other materials to assist the prosecution case in Japan, that would not be permitted by this treaty.
Right.
Just a clarifying question from Matthew. Does that mean also handing over of a person?
If you're within the territory of Japan, then it's not really correct to speak about handing over of a person because you're in Japan's territory. What Japanese police choose to do will be a matter for the authorities of Japan. If the person is, for example, in Australia, then it's not a matter for this treaty. It becomes a matter for our extradition arrangements and mutual legal assistance treaty. So this is not an extradition agreement.
Just on the legal side, an Australian Defence, for example, Australian Defence Force member has been arrested. Does the ADF or civilian equivalent provide legal counsel and or the wraparound service to that member?
There are, under existing determinations, persons who have been charged with offences that occur in the course of duty, and this occurs whether it occurs in Australia or around the world, are able to seek legal assistance at Commonwealth expense, and there are delegates who are able to make decisions in relation to the allocation of funds for such matters. There are different decisions to be made if offences are committed by an official outside the course of duties, so that is, committed in their personal capacity. There is always the capacity to make an application for Commonwealth assistance at legal expense, which can be dealt with in a discretionary fashion by relevant delegates.
Okay, I'm happy. Committee members? Sorry. Mr. Pike, and then, or Senator O'Neill, you go first, and then we'll come back to Mr. Pike. No, it's okay. I'm getting to the swing of things.
Okay.
We'll alternate. Yeah.
Oh, great. Thank you very much, Chair. So this is my first hearing on this committee, so I'm trying to, get across the cultural practices of how we transact. So correct me if I'm wrong. So at this point of time, we've got a 7.5-year negotiation that we're just trying to land right now. Mr. Jeffrey, were you involved for the entire process?
Thankfully not. I've been involved. That would be too long. I've been involved for the last 4 years. Actually 5 years. When I was in my previous job in Prime Minister and Cabinet during the Turnbull government, I was responsible for working with Defence, and I remember calling my predecessor saying, why had they not produced the treaty already?
Yep.
And then I didn't know that I would then be shifted into this job being responsible for negotiating it. But
Okay.
It was in the last 4 years where I was the chief negotiator, under which we reached in principle agreement on the negotiation, which was in 2020, October, in Japan,
Okay.
during the pandemic. And then last year we had the signature between the Prime Ministers.
Okay, so that's really helpful for me because in these negotiations, and I understand that this being the first one, it can be very difficult to get a template that is going to be culturally appropriate. So my first question is, the multiplicity of documents that make this up, how common is that in other treaty arrangements?
Well, as I mentioned...
Or is this unique?
It's not unique. It's very common in Japan's treaty-making process. And it's not unusual in other treaties that we have where there are annexes, implementing arrangements. If you look at, for example, the US force posture agreements that are at treaty level that enable the presence of the US Marines in Northern Australia, that's quite a complex treaty with subsidiary documents and implementing arrangements as well.
So you're aware of the critique of this treaty by academics who suggest that that structure leads to the risk of ambiguity and obscure meanings,
So
being a bit of a minefield for us.
Yeah, good point, Senator. I'm aware of that point in the submissions. As I mentioned earlier, the structure of the treaty reflects the fact that this was a long, drawn-out treaty, quite complex, quite challenging, and
So can I go back in time? Sorry, not to interrupt you,
Yeah.
because I have heard what you said there. But you said that in 2020 it got signed, you've been involved with it for 4 years. At what point did it sort of break out from a one treaty making document into what I would call the pressure release valves of other documents that are dealing with issues that there seems to be a cultural divide on? When did it take this shape and form?
well, I think Japan was pretty clear up front that it always wanted subsidiary documents, it always wanted a record of discussion
Because that's their cultural practice?
That's the way they proceed with treaties. And certainly for us, as we proceeded with the negotiations, in many instances, Senator, it was easier, more efficient to agree a subsidiary document which would set out in detail what we meant by this particular item in the treaty, rather than go back and try and renegotiate the text itself.
Yeah.
So it was a way in which we proceeded with the treaty over time, and we understand that the criticism that the number of documents or the structure could be confusing, but taken as a whole, actually its purpose is to ensure that there's no ambiguity around what the treaty says and how it will be implemented.
So I want to be persuaded by your argument, but I hear in your use of the words, and I'm assuming these are, directly coming from the text, we are not obliged to assist. You stated non-assistance does not break the treaty, but then in further questioning you've indicated perhaps a couple of different categories within what assistance might look like, when it might be provided in Air Commodore's response. I'm not convinced yet that we're very clear about exactly what would happen in a situation where a crime that would warrant the death penalty would be negotiated. Can you point to the part in the range of documents where I would find that confidence that our cultural practices, which don't necessarily mesh with the way in which the Japanese have wanted to structure this, would allow us to provide the kind of support and response that I think Australians will ask us to ensure is the case. And perhaps that involves something from Ms Coakley, around its intersection with extradition documents. Because at this point of time, I'm not convinced that our personnel are safe, and I want to point to my concern with regard to the practices that are in our submitters' documents from the ANU-LRSJ Research Hub describing hostage justice, Japanese police using prolonged interrogation methods to coerce subjects into confessing crimes regardless of whether suspects are guilty. I don't want to cast aspersions on the Japanese people or their legal system, but that does not match with the expectations of Australian citizens. So I hope I've given you the shape of where my concern lies. Can you give me a response to those concerns?
Senator, thank you. I'll ask Air Commodore Keane to point to the specific aspect of the treaty, the areas of the treaty that talk about the principle that where we have serious concerns about the death penalty being applied, we are not obliged to assist, because to assist in those circumstances would be to violate our international legal obligations with respect to the death penalty. So, Air Commodore Keane.
To be clear, yeah. I understand the bit we're not going to assist, but how do we assist our person when we're not assisting them? Where does the assistance for our citizen fit in the midst of we will not assist?
I might defer to DFAT colleagues in a moment, but really, Senator, the nature of your question, is it about the assistance that is provided by the Australian government to any Australian citizen who finds themselves in custody where they are facing a death penalty matter? So there are, and I'll defer to my DFAT colleagues in relation to those matters and processes.
Yes, Senator. In terms of Australia's obligations around mutual criminal assistance and extradition and the like, that's actually something that's led by the Attorney General's Department, so they may be best placed to answer those specific questions. What I can say from a general perspective in terms of Australia's international law obligations relating to the death penalty is that under our obligations under the second optional protocol, we as Australia have an obligation not to remove a person to another state, such as Japan, if they're in Australia, where there's a real risk that as a necessary and foreseeable consequence of that removal, they would be subject to irreparable harm, and that would include for us the death penalty.
But that's if they're in Australia when the
They're in
charge is
Australia.
brought. That's not if they're in the country when the charge is brought.
Indeed, indeed. And what I can also say more generally is that this treaty doesn't alter the scope of the international obligations that we have. And I'm unfortunately not in a position to go into more information about those mutual criminal assistance and that government-to-government assistance. It may be something that we have to take on notice for our colleagues at the Attorney General's Department to assist with. But those obligations exist independently and separately to this treaty. And the approach to negotiations, which our colleagues from Defence have outlined, was underpinned by that long-standing commitment from a policy perspective, but also those obligations being front of mind in the course of negotiations, those international and those domestic obligations. And
So
that
if
was
you
what
could
I
take
saw.
on notice the intersectionality there, that would be really good. And if I can just come back for a response to my first set of questions to you, Mr. Jeffrey, where can you point me to in the
So
document?
Article 21,
Yeah.
well, I think the point around the death penalty is that it is covered in different parts of the treaty text and it needs to be read together. So the three pieces really are central. So it's the treaty text, Article 21, the annex and the record of discussion.
So where in the annex?
I'll have to take on notice exactly where in the annex, but the Article 21 includes obligations on the parties to assist each other in the arrest and handing over of members of the visiting force or the civilian component of the receiving state, obligations on the parties to assist each other in carrying out investigations and collections, and the annex sets out the binding understandings of the parties in relation to Article 25 and Article 21(6) of the treaty. And I think Pat has the annex areas that are relevant in the cost of the death penalty.
As described earlier, Senator, the purpose of the annex was to go into further detail about some of the matters relating to the application of criminal jurisdiction and in relation to assistance. The annex makes it clear that not assisting in cases where it would be contrary to Australia's international criminal obligations will not constitute obstruction for the purpose of,
Which is not breaking the treaty, as you gave in your opening statement.
if we had to
Yeah.
do such
They're
a
not
thing.
obliged.
Yeah.
Yep, and then if I could take you then to the record of discussion.
So that's the agreed minutes.
The record of discussion. So that's the non-treaty level document that is attached to the treaty package.
Okay, so you're going to have to clarify that for me. I've got reciprocal access agreement.
So the main
Annex.
treaty text.
That's
yep.
the main treaty text. You've got the annex, which we've discussed, additional
have.
bits and pieces. I'll call it the pressure valve release.
Yep.
The next thing, agreed
The
minutes
agreed minutes. Yep.
and record of discussion. Is that
And
something
the
else?
final element, which is attached
Okay.
to the treaty package, and it's not a treaty level document, but a recording of the parties' mutual understanding in relation to the application of certain provisions, was the record of discussion on Article 21.
But it says that it's not legally binding, does not alter the scope of the parties' domestic laws and regulations and international obligations. So it's not.
Yeah, it's a non-treaty
It's
level.
not legally.
Yes, it's a non-treaty
It's not legally
level.
binding, so it is of lesser status.
It's a non-treaty level document which outlines the parties' understandings in relation to the application of the provisions. to
So
which
on
they
notice,
have
if you could
agreed.
give me the whole package of every bit that deals with the relevant discussion we've been having about death penalty, that would be helpful for me. Can I ask one question? Might have to be on notice, Chair. I'm not sure.
Yeah,
depending
if
on
you don't mind,
time.
Senator Neal, I'll come to Mr.
So
Pike.
the last question that I want to ask is, firstly, 8 treaty agreements, I believe, have been made so for status of force agreements, you said, and we thought we only had 5. A reciprocal status of force agreements, are they in place with PNG?
So reciprocal is France, Malaysia,
Yep.
New Zealand,
Singapore?
Papua New Guinea, the Philippines, Singapore, and
The USA?
The United States
the
is
United
Yeah,
States
okay.
is one way,
All
just
right.
Australia.
Just on the Philippines, so this is the Defence website. There's no status of forces agreement listed with the Philippines. So we've got Malaysia, New Zealand, Papua New Guinea, Singapore, and the US.
France.
5.
Yeah.
It may be referred to as a defence cooperation agreement. I'll need to check
So I can take the committee to it. It's the agreement between the Government of Australia and the Government of the Republic of the Philippines, entered into Canberra on 31st May 2007, entered into force 28 September 2012.
Okay, so this is a suite of slightly different names, but they all do the same thing, so that updates our information. My question is, though, of those countries, the PNG, USA, Singapore and Malaysia have the death penalty?
Of the 4 countries with whom Australia has a treaty for the presence of its forces in the other host state,
Yes.
4 of the countries have the death penalty. Those are Papua New Guinea, the Philippines, Malaysia and Singapore. And then of the 4 agreements with those countries, we managed to secure exemptions from the application of the death penalty for the visiting force in relation to Papua New Guinea and the Philippines, but not in relation to Malaysia and Singapore.
The US?
The US is a one-way
One-way,
for the presence of US forces in
Here.
Australia.
Yeah. All right. I'll come to Mr. Pike. But if you obviously note the questions that Senator Neal has put
Yeah,
on,
and the question is how
on
to
notice.
negotiate that, and why is that negotiation unable to be achieved in this context? Because I think it would give greater comfort to the Australian people.
Right.
Thanks.
Thanks, Chair. The conversation's moved on a bit, but it goes to, well, still on the same theme in relation to the non-obligation to assist. Can I just get clarity that that only relates to matters that would result in potentially in the death penalty? So if an Australian ran into trouble in a lesser offence, then there would still be an obligation to assist, the same way that I'm sure the Self-Defence Force of Japan may assist with local jurisdictions in coming to some sort of, dealing with some sort of prosecution there. And then second part of the question, we've talked a lot about, the options of or what might occur with an Australian in Japan. Conversely, is there any similar caveat around any aspects of Australian law that the Japanese have got an obligation or non-obligation to assist there, or are they fully, if a Japanese self-defence force member ran into trouble in an Australian jurisdiction, is it the expectation that the Japanese military would fully cooperate with Australian jurisdictions?
Thank you, Mr. Pike. To answer your first question, in the question around, and can you just repeat it again? It was just that your first one was...
Yeah, just the non-obligation to assist, it only relates to if someone was going to be charged with something that might relate in death penalty.
It's Australia's international human rights legal obligations go beyond the death penalty.
Mm-hmm.
So the obligation to assist, we are not obliged to assist under this treaty when it comes to the death penalty, or when it comes to other cruel or inhuman punishment that we have agreed under our international legal obligations to resist. Our DFAT colleagues can set out what those cruel and inhuman punishments are. There is a specific list under our international legal human rights obligations. With respect to your second question, you're right to note that this is a reciprocal agreement. So whatever obligations are upon us as the sending state in Japan are upon Japan as the sending state in Australia. But the specific arrangement that Australia would not be obliged to assist where we have serious concerns about the death penalty or other punishments that would violate our international human rights obligations, that is not reciprocal, because we don't have the death penalty in Australia. And it illustrates A, that it's not reciprocal, and B, the lengths that the Japanese system itself went to compromise to ensure that it could come to an agreement with Australia in a way that ensures that there is no violation of Australia's international legal obligations. So that's an important point to note. Pat, would you need to add anything to that point?
I would just probably take Mr. Pike to when this matter was discussed with Japan, and it's recorded in the record of discussion, which is next to the treaty, that Japan itself did not envisage any concrete situations where, at this end, at the Australian end, where Japan would refuse the assistance in carrying out the necessary investigations, whereas in turn Australia identified the issues that related to our international legal obligations.
Presumably, the only circumstance where this issue would arise is, where if a Japanese citizen, a member of their armed force or the civilian component, committed an offence in Australia under which the sending force had the primary jurisdiction, so it could be an offence by a member of the visiting Japanese force against other members of the Japanese force. If there was a sufficient likelihood that a person in that circumstance would be subject to the death penalty in Japan, a Japanese citizen, we would be obliged under the second optional protocol to not provide assistance in relation to that person.
Not necessarily under the second optional protocol, but more broadly under the ICCPR. Just in terms of coming back to the question from Mr. Pike in terms of the non-death penalty obligations, international human rights obligations that Australia has in this space, in terms of that non-removal or what obligations we have in terms of our protection obligations, it would also include, and I think as Mr. Jeffrey noted, the torture, cruel and inhuman and degrading treatment, so that might include something, for example, indefinite periods of solitary confinement, for example. So those are some examples of the other kind of non-death penalty but still significant obligations. Arbitrary deprivation of life under the ICCPR as well. And the torture ones come through our obligations under the ICCPR, but also the Convention Against Torture as well, to which Australia's a party. And so the record of discussion, as Air Commodore Keane has explained, encapsulates not just the death penalty, but of course in this context the death penalty is a particular flashpoint for discussions during the negotiations.
You're all good, Mr. Pike. So I've got Senator Cox and then Senator Van.
This is just a point of clarification, and it's in a similar vein, so thank you for explaining that. But my understanding is the other 4 agreements that we have mention that there's no requirement. Sorry, in this one we actually say there's no requirement to give sympathetic consideration to the request of the sending state to be entrusted with the custody of a person pending the conclusion of judicial proceedings. Can you just talk me through the implications of that? Because it doesn't actually appear in the other, this is in the brief that we got, it doesn't appear in the other 4 agreements, so...
Could you clarify which text that is coming from?
We got it in the briefing that we received around the highlight about what the key difference is between this agreement with Japan and the other agreements that you've listed. When we talk about not having the requirement of sympathetic consideration, I think that's the question that Senator O'Neill was asking. Everyday Australians will be asking us that. Having pending judicial proceedings and keeping someone in custody is not something that's consistent with Australian law. So why is it that it only appears in this Japanese agreement and not in the other 4 agreements? Is at the heart of that question. Is this something that they are pushing from their end rather than from ours?
We're just, Commodore Keane is just thinking that through. The concept of sympathetic consideration is not something that we dealt with in the course of the negotiations. So the distinction that you're drawing between this agreement and our previous agreements is not one that I've addressed or had to deal with in the context of the negotiations. So we'll take it on notice for now. We can give it some thought, and we can provide you a more considered answer, Senator.
That would be great.
Thank you.
It's just obviously these are the things that we would obviously be considering in this. If it's specific to this agreement, is that a cultural factor, as Senator O'Neill's pointed out, versus a judicial proceeding legal response that is consistent with it not being obliged to assist, but also more, fulsome, because there are compassionate or sympathetic grounds which obviously would play into being kept in custody in a separate country.
Yeah, and I just want to clarify, Senator, as well that were an ADF member be subject to Japanese domestic criminal proceedings, prosecution, is in custody, it's important to underline that we would, of course, be engaging closely and constantly with the Japanese authorities in the case, and we would be, and certainly, were it to be the person be accused of a criminal act that could attract the death penalty historically in Japan, we would be making every effort to advocate against the application of that punishment and to ensure that we are providing support that we can. And of course that's not just, of course, to ADF personnel, but any Australian citizen that commits such a crime in Japan would be subject to the same parameters. Thank you.
Thank you.
Senator Van.
Thank you, Chair. You mentioned that we have agreements, reciprocal agreements with Malaysia and Singapore. Obviously, they have the death penalty.
PNG and New Zealand as well.
Thank you. Malaysia or Singapore, I know, and Malaysia, I believe, use corporal punishment as well. Are they excluded in any way, or are we exempted by our international human rights law obligations under those agreements?
So our international obligations, and including the obligation not to assist, would include any circumstance where a person may be sent back to a place where they may suffer irreparable harm. So those are things like cruel and inhuman treatment,
So
torture.
caning, in the Singapore example, would that be?
I find it difficult to answer as to whether that meets the level of international legal obligations.
I couldn't answer it in my own head either, hence the question.
Yeah. However, the benchmark that we have to work to is whether a person is likely to suffer irreparable harm as a consequence of being sent back to the state where they are subject to that.
Great, thank you. Thank you, Chair.
Ms Chesters.
Thank you. I'm just going to change topic entirely, so I'm sorry if I interrupt anyone's flow of thinking. I just wanted to sort of step back a bit, and with this agreement, there will obviously be weapons that Japan will want to bring to Australia and vice versa. Australia will want to bring, and the whole army. I don't just talk about this because we make the Bushmasters in my electorate, which I know we gifted to Japan back in 2015. But I was hoping that you could just, for our sake, are there any equipment or weapons that Japan has that we currently have bans in Australia that we wouldn't want to see here? And would they actually be brought here, and under what context would it be? Is that anything that people in Australia would be concerned about, and equally Japan would be concerned about, given the political pressures that they've had in this entire space in terms of them expanding their kind of focus on military in recent years?
Thank you for the question, Ms Chesters. As you, I think you'd be aware that the treaty itself does not have any defence industry component.
No.
So important to clarify what it's not. It's not a mutual defence agreement. It's not a obligation to come to each other's defence. It does not, unlike other, for example, defence cooperation agreements, suggest that we should deepen defence industry collaboration to produce.
I'm not
Yeah,
suggesting
all
that they buy more Bushmasters
Yeah.
and Hawkeyes as
No,
much as I'd
yeah.
love it. I know that this is a disagreement. I was just sort of, just thinking about the military, like what they actually have as an army. Is there anything that we would not want to see in our country that they might want to bring here? And how does this agreement deal with those conflicts? And equally, do we have any equipment that they would not want to see on their shores in Japan? And how do we work that through with this agreement? Or is this even the agreement that we do that?
So I'll ask Air Commodore Keane to address the specific question around how we handle the carriage of weapons under the treaty. I'll just get onto the record, of course, that Japan is, by its constitution, maintains a self-defence force.
Yep.
Its constitution, post-war constitution, is a pacifist constitution. It has not historically developed capabilities to project power offshore, and so in terms of its weapon systems, it is defensively oriented only, and indeed in some areas has been constrained in its ability to develop certain capabilities. And so, as a general rule, I'm not of the view that we need to. There would be certain classifications of weapons that would be prohibited in Australia that would affect this. But Air Commodore Keane, do you have anything to add on that front?
Thank you, Mr. Jeffrey. So the treaty does make provision for the importation and exportation of equipment, so the stuff that we take to Japan, the stuff that they bring back. The treaty provides that that shall be subject to the applicable laws and regulations administered by the import and export authorities of the receiving state. So what that would mean is it will be subject to the normal defence export and import controls, so our normal regulatory arrangement, which would mean that a weapon that could not be imported into Australia under our law could not be bought here by Japan, and vice versa.
Are there any examples of that we know of?
I would have to take on notice. We are signatories to a range of treaties, like the Cluster Munitions Treaty and the Treaty in relation to anti-personnel landmines, which would create equipment that would create difficulties for us. We're a partner to seek to bring such equipment to Australia.
RPGs and things like that.
There would be some difficulties, particularly in relation to weapons, where Australia has signed a treaty on a ban or those sorts
Like
of things.
nuclear weapons, for example, because they have a nuclear industry, but am I right in assuming they don't have any nuclear
don't have a
weapons?
nuclear weapon
No.
system.
No, they're big proponents of the Non-Proliferation Treaty on nuclear weapons, aren't they?
They are.
That's correct.
Would they have any concern about our expansion into nuclear submarines?
So Japan is a littoral, as a self-defence force, it doesn't need and hasn't sought long-range submarines. But Japan very well understands Australia's strategic circumstances and that we do not just need submarines with a littoral capability, but with a long-range capability. Japan's government has been on record as being very supportive of Australia's decision to acquire nuclear-powered submarines. And as I said at the earlier today, our defence and security relationship is now at a point where we see each other as important linchpins to each other's regional strategies. And so a more capable ADF is seen in Japan as a net plus for Japan's security.
So this agreement talks about joint activities in Australia and in Japan. Does it go into, or is it another agreement where it talks about joint activities, say, somewhere else in the Pacific?
It doesn't encompass activities extraterritorially. It encompasses activities that we would do in each other's territories. But certainly in line with our country's strategic alignment and our desire to work together more broadly in our region, both bilaterally but also with other partners, we're doing more. For example, you may have seen that Japan deployed air assets to Australia earlier this year in response to the humanitarian crisis in Samoa as a result of the undersea earthquake and tsunami. So that's an example of us seeking to use each other's territory more directly to support third parties.
I would add, Ms. Chesters, it does it would apply to an offshore activity that was linked to an onshore activity. So if there's an exercise in Australia with aircraft and they're using the West Australian or East Australian exercise area, offshore areas, then the treaty does have application to those activities. But otherwise, it must be linked to an activity in the host state.
Senator Chandler.
Thank you very much, Chair. I just have a couple of questions about the interaction of the agreement with UNCLOS. If we've got someone at the table who can answer that, that would be fantastic. My understanding is that the agreement obviously allows receiving states to prescribe routes and restrict movement through certain areas. So how do we see this interacting in terms of Australia's ability to peacefully pass through, or I should use the technical term, innocently pass through territorial waters, and do we have any concerns around that?
Yeah, look, thank you for the question. The article, I refer you first to Article 5 of the treaty, which seeks to ensure that when an Australian warship's participating in cooperative activity in Japan's territorial sea and internal waters, and vice versa, that the sovereignty of the receiving state's respected. We don't believe in practice that there's any inconsistency between what we've agreed under the RAA and UNCLOS. The exercise of innocent passage rights, which is the ability for a warship to travel, provided it does so in an innocent manner through the territorial sea of another state, can be distinguished from circumstances that this covers, which is about warships visiting another state to undertake mutually determined and cooperative military activities in the territorial and internal waters of the coastal state, noting that it's the latter that would be covered by this agreement. In general, there's no significant concerns with parties being able to prescribe navigation routes during a cooperative activity. In many circumstances, that's just common sense, not to interfere with commercial shipping, sensitive environmental areas or safety. Those are things that we indeed do ourselves with some of the activities of countries visiting Australia. We're quite comfortable with the way that this interacts with our otherwise freedom of navigation rights under the United Nations Convention on the Law of the Sea.
And have there been any discussions so far in terms of any limitations that might be placed by either Australia or Japan in relation to the agreement, or will that be, again, one of these things that we operationalise after the treaty is agreed upon?
It would be activity by activity if there were sensitive areas or routes that in relation to the place where we were choosing to do a particular exercise or activity. So there are many places in Japan's narrow and shallow littoral waters where it's actually quite appropriate for the purposes of safety to use pilotage, even though under international law military vessels generally aren't required to use a pilot, but it is a common practice for us to do so.
But no formal discussions on that?
No.
Okay. Thank you, Chair.
Thank you, Senator. I mean, that's a good question. I guess the technical thing that's been raised is that it makes perfect sense if you're undertaking an activity that you've already agreed, that there'll be a conversation about routes. But I guess the point about this is you've got international agreement that in a set of circumstances, one country will allow the prescription of a route, and I guess it is a bit of a technical international law question, just as to whether having an international agreement that allows the prescription of a route, which contravenes what is otherwise the right of someone to travel innocently on whatever route they decide at whatever time of the day, is inconsistent. But anyway, I'll leave that to the international legal scholars to argue about. Just a follow-up question, the one about pilotage in the Torres Strait. The material we've provided suggests that the agreement is more or less in keeping with the piece of Australian domestic legislation that covers that anyway, so there's no inconsistency between those two things. But is there anything that you can offer us in relation to what it does in terms of dispensing with the requirement for pilotage in the Torres Strait?
So this agreement does not actually impact that. So under Australian law, there is a pilotage scheme in place in the Torres Strait. However, the submissions that you've received are quite correct. That the pilotage scheme under Australian laws does not apply to sovereign immune vessels, so to military vessels of states are not required to take on mandatory pilotage in the Torres Strait under Australia's law, and this agreement doesn't change that. Doesn't it change Australia's approach?
Okay. Are there any other questions, Mr. Burrell?
This question may be out of the realms of this discussion, but I just want to raise it. And I understand that the document says that this treaty does not create an alliance or any alliance type obligations. But I'm just interested in what happens to the treaty and elements of treaty if Japan's leadership, constitution and/or strategic intent changes significantly.
Thank you, Mr. Grella. So the treaty itself is not a normative agreement. It doesn't frame our activity to do a certain thing, to secure prosperity in the region or to protect each other. So often these are the things that are covered by formal alliance treaties, mutual defence pacts and so on. So doesn't tie us to a particular geopolitical situation in the region. All it does is provide the mechanism through which we can operate more closely together in the military domain. And the trajectory of the relationship bilaterally, more broadly, will determine and govern how we use the RAA in practice. So, if Australia and Japan in future diverge strategically, that they adopt different strategic positions, then, you could make an argument that the RAA would end up becoming something not much utilised. But if our positions are to continue to converge strategically, I would argue that the RAA will be an increasingly important piece of bilateral architecture.
And I think that's probably the likelihood, but there isn't, a chance, as the Chair said earlier, things of vanishing chance can happen. So if Australia and Japan's strategic intent diverged and, Japanese military personnel are in the country, I'm just wondering, does the treaty deal with that at all?
Again, it doesn't. It ensures that the activity of the sending state is completely consistent with the sovereignty of the receiving state. So, were we to deem that activity unwarranted or unnecessary, it would be completely within our rights. The treaty was negotiated with to have no bearing upon our sovereign rights and our international legal obligations, but rather to ensure that we could do what we wanted to do together. The strategic circumstances, as you have noted, are driving our two countries together in ways that we have not seen before, and we think that, as I mentioned at the beginning, this treaty will allow us to operate in a way that will help us as two liberal democracies in the Indo-Pacific and to US allies to be able to navigate a much tougher region together.
Thank you.
Good. Mr. Bernal? Okay. Look, I'll just finish by coming back. I think it would be helpful for the committee because the next hearing is going to feature those who have an interest in the death penalty question in particular, and I think it's just worth it if perhaps you can take on notice, whether it's for DFAT and the AG's department, just to come back to us with something that is, in as simple and practical terms as possible, looks at the kind of scenario that we're considering. So, my understanding is that if you've got Australian personnel and they happen to be based in Japan, to take an example, if one was to steal the belongings of another, that would be an offence. I mean, it's interesting. Presumably, that person would be tried for theft under Australian law, which we extend, even though that's an offence that's committed extraterritorially. It's not committed in Australia. It's an offence of theft. There would be mutual jurisdiction, but because under this agreement it's from a member of the visiting force upon another member of the visiting force, that person will be charged with theft under Australian law, right? And that would be the case for other offences, even more serious offences, where they were either against the person or property of the visiting force or civilian component, or in the commission of a person's official duties. And we've been given reference to an example that involves the US forces in Korea, where US forces were driving from somewhere to somewhere else in the course of their official duties, and a traffic incident occurred that resulted in the death of South Korean civilians. And the question, of course, was the culpability of the driver. You know, in those circumstances, if that was to happen to Australians driving from somewhere to somewhere else in the course of their official duties, then they would be charged or considered as to whether the driving causing death was criminally culpable, and they would be charged under Australian law, and presumably, if they were found to have driven culpably, imprisoned in Australia, perhaps. The situation we're trying to kind of understand is this narrow window, however vanishingly small, perhaps, where an Australian commits an offence in Japan, not in their official duties, or where there's some dispute as to whether it's in their official duties, and they end up in the custody and within the criminal jurisdiction of Japan and are charged and are sentenced to death. You know, that clearly is possible. It's possible. And the agreement has done an enormous amount to try and reduce that to the smallest possible circumstances, but it's still there. And I think it would be just useful if you can come back to us with something in writing that really makes it clear what that window of possibility is, because that's what the next hearing is going to be focused on, because that's the submissions and the evidence from the other people. And I think having the government side of it will be useful for us. Have I put that clearly
Thank
enough?
you, Chair. Just to clarify, you'd like something in writing?
I'm asking you to take it on notice.
Yeah, take it on notice. Yeah, good. Thank you, Chair.
Okay, well, thank you for your attendance here today. If you've been asked to provide any additional information, like I just have, would you please forward it to the Secretary within 7 working days? As I said in my opening remarks, it's the witness's responsibility to meet this deadline in a timely manner. You'll be sent a copy of the transcript of your evidence when it becomes available, and we'll have an opportunity to request corrections to transcription errors. Otherwise, I declare this public hearing closed. Thank you.
Chair.